Hello, everyone. I'm so excited and happy to be moderating this panel. We are so lucky to have some really good friends of mine presenting during this panel. Our first speaker will be Kurt Decker, our honoree. And he has been with the National Disability Rights Network, NDRN, since it was founded in 1982. Before NDRN, Kurt served as the director of the Maryland PNA and was the director of the Help Resource Project for Abuse and Neglected Children. So Kurt will be showing a film about Willowbrook, and it may be a little bit hard for some people to see. So you may want to not participate in that part if it gets too hard for you. So first of all, we're going to start it out with Kurt. And Kurt's going to tell us how the PNA system originated and how it has evolved into further reaching authority and protection advocacy rights for people with disabilities.
Thank you, Tia, and thank you to Tash for putting together this wonderful symposium and this particular session in the symposium. And thank you for making me your honoree. That's quite humbling. I'm very excited about talking about how this network came to be. And I think the best way to sort of start is to show this video of the Willowbrook tape of the Willowbrook Institution in Staten Island, which was the largest institution for people with intellectual disabilities in the world at the time. And so we'll run that video right now, and then we'll pick up the conversation when it's finished.
Willowbrook State School, Staten Island, New York City. The world's largest institution for persons with developmental disabilities. In 1965, the census was over 5,000 individuals. That year, Robert F. Kennedy toured Willowbrook.
I visited the state institutions for the mentally retarded, and I think particularly at Willowbrook that we have a situation that borders on a snake pit, and that the children live in filth. But many of our fellow citizens are suffering tremendously because lack of attention, lack of imagination, lack of adequate manpower. There's very little future for the children or for those who are in these institutions.
7 years later, nothing had changed. Until a handful of voices joined together to make one voice. One voice for change.
I was a medical doctor at Willowbrook. I was brought to Willowbrook for the first time on my pediatric rotation during my internship.
There are 5,300 patients at Willowbrook, which is the largest institution for the mentally retarded in the world. The ones that we saw were the most severely and profoundly retarded. There are thousands there like that, not going to school, sitting on the ward all day, not being talked to by anyone, only one or two or three people to take care of 70 people on the ward, sharing the same toilet, contracting the same diseases together. 100% of patients at Willowbrook contract hepatitis within 6 months of being in the institution. Most patients at some time in their life have parasites. The incidence of pneumonias is greater than any other group of people that I think exist in this country.
Dr. Wilkins discovered a house of horrors behind the walls of Willowbrook.
It quickly dawns on you that this is an operation which is for the purpose of housing people without a plan for their life, just as the cliche goes, a warehouse for human beings. It was very overt. You didn't have to think much to figure that part out. They were just sitting there, just nothing to do all day, just sitting there and rocking.
After being fired by the administration, Dr. Wilkins, who still had a key, turned to his friend Geraldo Rivera.
I first heard of this big place with the pretty sounding name because of a call I received from a member of the Willowbrook staff, Dr. Michael Wilkins. The doctor told me he'd just been fired because he'd been urging parents with children in one of the buildings, building number 6, to organize so they could more effectively demand improved conditions for their children. The doctor invited me to see the conditions he was talking about, so unannounced and unexpected by the school administration, we toured building number 6.
His key unlocked every door in Willowbrook.
There was a big entrance at Willowbrook where the cars could come, and they had security people checking, and they were not going to let us on the grounds. But it's a huge place, many, many acres. And so we simply parked on the periphery, and there was this stone fence, and we vaulted the fence, and we ran the 200 yards to the nearest building and easily got in.
There was one attendant for perhaps 50 severely and profoundly retarded children. Lying on the floor naked and smeared with their own feces, they were making a pitiful sound, a kind of mournful wail that it's impossible for me to forget. This is what it looked like, this is what it sounded like, but how can I tell you about the way it smelled? It smelled of filth, it smelled of disease, and it smelled of death.
When I stepped into that ward and threw open that door with my stolen key, it was the defining moment of my life.
Dr. Wilkins' key and Geraldo's camera started a chain reaction that ended in freedom for those in Willowbrook. It also resulted in the federal laws that created a network of protection and advocacy systems, independent legal advocates for the rights of persons with disabilities, so that no one would ever be without a voice again.
Well, that's pretty powerful stuff. As many times as I've seen it, it still moves me and is quite concerning. And I'd love to say that those places don't exist anymore, but we all know that they still do. Maybe not that level of size and those conditions, but there are still hundreds of thousands of people with intellectual disabilities in those kinds of congregate facilities. So as the video said, Congress then reacted to that expose by Geraldo Rivera. As an aside, it's a powerful example of how media can be a great advocacy tool, and we all should be thinking about how to continue to use the media to shed light on the conditions that people with disabilities experience. And Congress added to the Developmental Disabilities Act this concept of protection and advocacy. And it was a very interesting set of principles that I'm happy to say continue today. And has grown from representing people with intellectual disabilities as a result of the Willowbrook tape, but now represents all people with disabilities with these same underlying concepts. We have a program now in every state and territory, and a program in the Southwest serving the very isolated Native American population. So we have 57 programs, and even though the names are different in some places, everybody should know there is a protection and advocacy resource in your state or territory. Congress gave us incredible legal authority, which we have been able to maintain to this day, despite lots of attempts at changing it. And so P&As have the full range of legal advocacy tools to use to end discrimination against people with disabilities. Doesn't mean they use that all the time. And I would say maybe 5 to 10% of our work actually ends up in litigation, but it certainly makes all the work of the full range of P&A staff, advocates, that can really make a difference in people's lives because they have that legal clout. So that's the critical aspect of our work. We have to be independent. The P&As are supposed to be independent from any service provider because we want people with disabilities to understand that we are their advocate, speaking for them, and that we're not beholden to any state agency or any government authority that may in fact try to limit our ability to make change. They also gave us, because of the institution and sort of referred to there, they gave us incredibly powerful access authority. We can go into at that time, any facility where people with disabilities resided and have access to them and to their records. And we have expanded that authority over the years so that now includes access to schools and education, to sheltered workshops. And most recently, we were able to get access to the separated children facilities down on the border. And so this access authority has been challenged many, many times by lots of people who don't like the P&A showing up at their door, but it's been upheld in myriad of court cases, and it's really one of the most important aspects of our authority. And we also have the ability, and as a result of the legal work and independence, we can have a continuum of remedies for people with disabilities. We can work with the individual who comes to us at any point in the system. If they need self-advocacy training, if they need some rights training, great. If they need more help in a more formalized setting, such as administrative hearings, we can do that. And then, as I said, we can go into individual litigation and then systemic class actions. We also have the ability to bring cases in our own name, standing. I think it's a very important aspect that occasionally when we're representing prisoners or people that are in facilities where we can't be in there constantly to protect them, they're often afraid of retaliation. And so the P&A can, in those situations, bring a lawsuit in the name of the P&A and protect the anonymity of the complaining residents. So it's a very powerful tool to make sure that we can really make a difference in people's lives. As I said, the program was basically created to do investigations in abuse and neglect based on Willowbrook, but that we came into being in 1978 around the country, these little programs, just when IDA came online. And just as we were opening our doors, parents of kids with disabilities came rushing in and saying, hey, we've got this new statute. It's an entitlement to a free and appropriate education, and we need your help. We have due process protections here. And so almost instantly, as we started to become a viable entity, bifurcated into continuing to do our abuse and neglect investigations in the large facilities, but also getting involved very early on in special education. And what we learned as time went on is like this was a great model working for people with intellectual disabilities. Why limit it to just that population? And so over our journey for these last 40 years has been to take opportunity, other scandals that come along. They say never waste a scandal, and we don't, to try to increase and expand the breadth of the P&A system. And right today, there are 9 programs based on the same model that represent all people with disabilities. And so we're now clearly a cross-disability program that now can hopefully meet the needs of anyone who is experiencing problems with the service system or the quality of their life. The program right now stands at about $180 million. Sounds like a lot of money, but the need is great, and we're still, unfortunately, forced to set priorities that may, in fact, have to turn people away, people who could really benefit from our services and we know we could help, and we just don't yet have the full range of resources to do that. Not surprisingly, we experience attacks on our program. We're not that popular. We're challenging the system all the time. And so there are often various people who try to interfere with our various authorities and ability. We're experiencing a few things right now in Wyoming and Ohio where legislatures are coming in and don't like some of the things that P&As do. We certainly upset lots of people, certainly service providers, family members who unfortunately still to this day feel that an institution or a large congregate setting is the best place for their child. And so they are often very annoyed when we come in and really try to move the service system to a more community integrated model. And so they resist and fight back. And so that's something that we at NDRN constantly have to do to make sure that we can maintain these very powerful authorities and this range of issues. I want to talk a second about how NDRN works and should work, and the P&A should work with self-advocates. They are certainly a critical aspect of anything that's going on in the community. I try to tell my members to not just get into your little legal box and run off and file a lawsuit without looking left or right. We think, and again, based on some of the attacks we get, it's so critical that when we do our work, we involve the entire disability community up front, especially self-advocates, to get their input, to get them to help us identify where the problems are, often help us coming into facilities to convince their peers that it's okay to challenge the system. It's okay to come out into the community. The community is fine. And then also help us if we win and if we are able to downsize large congregate facilities to make sure those people are protected. One of the problems, I think, with sort of the legal rights approach to community integration is we sue. The service system fights us tooth and nail. They lose. And then the next minute, they've got to change their whole concept of fighting us and develop a community system that is quality. And I feel so strongly that we cannot bring people out of large congregate bad facilities and put them in small bad facilities. We have a commitment to folks that when we tell you you can have a better life in the community, we have to make sure that that's true. And unfortunately, so many states, having been pushed to develop a community system, aren't experienced, don't put the same amount of money in the community that they have put in these institutions. And we then discover, the fact that we have maybe possibly jeopardized some people. We've certainly seen situations. In one case, I can tell you, the P&A actually had to go back to the state and say, stop, do not bring these people out of the facility yet. You are not ready to serve these folks. Some of them are medically fragile. They could live in the community if there were the panoply of support services to let them live in an integrated setting, but you have not done that yet. So we are in this very interesting, when we're not the kind of lawyers who run in, bring a lawsuit, win and leave, we have an obligation to make sure that what we have wrought, in fact, really helps and makes people's lives better. So I am very happy that we have this alliance with TASH and that we can work, and we work very closely with SABE and the other self-advocacy groups to make sure that there really is a comprehensive approach to bringing a full community integration to people with disabilities. And I'll stop there and pass it on to my, my colleagues and be available for questions if necessary.
Thanks, Kurt. The theme continues, from the first two. And Tia is now going to introduce the next panelist, who will nevertheless be eloquent as always.
Right. Okay, the next panelist is Jack Derryberry, who received his BA in history at Duke University in 1969 and his JD at the University of Tennessee in 1972. His practice has consisted of class action law litigation on behalf of persons with disability, Social Security disability matters, special education law, state Medicaid appeals, and more. He served as counsel in People First of Tennessee versus Arlington Developmental Disability Center and People First of Tennessee versus Clover Bottom Developmental Center. Jack, welcome. And can you, as an attorney with the P&A and Disability Rights of Tennessee, with your P&A, what types of violations of the ADA and Olmstead are you investigating, and how do you work with self-advocates?
I think probably the biggest barrier that faces persons who are advocating for people to get out of institutions or to get better services in the community is or are waiting lists. And I say that to lead me into what I think is a very good example of self-advocates and the protection and advocacy systems cooperating to get a good result. And this is a CLE. The case is Brown versus Tennessee Department of Finance and Administration. And I'm going to talk about 3 decisions in that case over a course of 2 years. The first one was in 2007, and before that decision came up, the Protection and Advocacy System had filed a case challenging the waiting list and the size of the waiting list in Tennessee under the now largely defunct reasonable promptness standard, which was mostly killed off by West Side Mothers case. But before that happened, the P&A filed that case, and shortly thereafter, People First of Tennessee, who I was representing at the time, along with Judith Graham and Earl Schwartz here in Tennessee, filed a case also challenging the waiting list. We got a class certified, which would be basically all the persons who were eligible or might be eligible for services and who were on the waiting list. And we negotiated a settlement, and that settlement provided, among other things, that the decree would last for, I think it was 3 or 4 years, and the state would expand its home and community-based services waiver by 900 slots and its self-determination waiver by 600 slots. Well, that went on for 3 or 4 years until the state decided they would file a motion to dismiss and say the law had changed based on West Side Mothers. And in a decision at 2007 Westlaw 2710704, Judge Eccles in the Middle District found that the settlement agreement or consent decree was enforceable and said that the state had to keep doing it. The state, of course, appealed, went to the Sixth Circuit, and the Sixth Circuit in 2009, 2 years later, at 561 Federal 3rd 542, said, well, West Side Mothers trumps Judge Eccles' decision, and we reverse, but we don't completely reverse. This decision and the settlement agreement were still there. Sent it back to Judge Eccles, and later in that year, the settlement agreement, which had a time limit on it, and Judge Eccles said, well, the settlement agreement is going to continue until the end of the year, which is 2009, and was about 4 or 5 months left in the year. But the point of that is that the protection and advocacy system saw a problem, which was the waiting list. It continues to be a problem all across this country. Tennessee's waiting list now is 5,000 people, but that is probably less than 10% of the real waiting list. It's probably 40, 50, 60,000 people in Tennessee. Most people don't apply because they don't want to deal with the hassle and they don't want to deal with the frustration. So challenging the waiting list is one of the best things P&As could do at the time, and in conjunction with People First, a decree was entered that basically expanded the number of people getting services in Tennessee by about 30 or 40%. And this is important because one of the things that is necessary for waivers, home and community-based services waivers, or any other kind of waivers, you get a sort of a critical mass where you have enough people involved in it, enough money involved in it, the providers feel, okay, we can make a go of this financially, and they'll start a process and they'll agree to provide services. And I think that gives an example of the P&A and self-advocates working together to get a very, very good result, which, those waiver service slots are still there to this day. I'm going to talk just briefly about the Arlington and Clover Bottom cases because those were the first cases. The Arlington case was the first case in which a self-advocacy group, People First of Tennessee, filed a case challenging the segregation of persons with disabilities in developmental centers. In this case, all these persons were people who were intellectually disabled. And in that case, the United States, the Department of Justice had investigated under CRIPA, the Civil Rights of Institutionalized Persons Act, and made findings which were just egregiously horrible. For instance, without being overly graphic, one of the things they found was a young man who was profoundly retarded who had a Foley catheter in his penis, which was corroded along its entire length. And that was the sort of thing, or people who were just left in feces or unattended for a long period of time. This prompted People First to file a case, and shortly thereafter, the Justice Department filed a case challenging these conditions. Judge McCullough let the Justice Department case go forward, and People First case sat moot for about 3 or 4 years. The state did file a motion to dismiss. The judge denied that, and so People First was still in court, but they weren't actively participating in the case until September of 1995, at which time the judge became very frustrated with the state of Tennessee, and all of a sudden entered an order granting people first motion for class certification, and a few days later entered an order consolidating the cases and entering the consent decree in the United States' people first case as a final order in the people first case, and consolidated these cases for purposes going forward, which the case, this was 1995, Arlington didn't close till I think it was 2012 or thereabouts. So people first was in the thick of it from there on out. The site on the denial of the motion to dismiss is 878 Federal Sup 97. That was in 1992. And then in 1998, the Sixth Circuit upheld Judge McCullough's decision to certify the class and approve the settlement in the United States case as part of people first case and consolidated. That was 145 Federal 3rd 1332. And subsequently, the Parent Guardian Association, which had intervened in the case, also appealed the Sixth Circuit decision approving Judge McCullough's order. And certiorari was denied at 119 Supreme Court 510 in 1998. So at that point in time, People First is, as a self-advocacy organization, is in it for good. And I think that a very important point of this is that self-advocates, you know, people who do not know persons with disabilities well or are not well acquainted with them may, you know, have a demeaning opinion or a lesser opinion. But what they don't realize is that self-advocates get it. And, you know, I think a very good story about how they get it was that there was a guy named Bill Gates, who was the president of People First of Tennessee at the time, and he had been a resident during his career at both the Clover Bottom Developmental Center and then later at Arlington, and had gotten out and is now living independently with his brother and doing fine. But we were having a discussion with the state of Tennessee, Department of Intellectual and Developmental Disabilities, and the Department of Justice, and the Parent Guardian Association and People First about trying to come up with an agreement that would settle the Clover Bottom case and create a path out. Parent Guardian Association had fought this, you know, from the beginning, and was opposed to anything that would, in essence, close institutions. And their lawyer was, well, to use a polite phrase, perseverating about that and why that the institutions should not be closed. And Bill Gates had been sitting there and he hadn't said anything the whole meeting, and all of a sudden he pops up and says, "Well, you're just trying to go back to the dark ages." And the room went silent. Nobody said anything. And really, the beginning, that moment pushed the case and the discussion in the case and the state's approach and position in the case over a tipping point. And after that moment, literally that moment, the Parent Association was fighting a defensive uphill battle. They never were ever on the offensive again. And at the end of this, some several years later, we had the Nat T. Winston Center for Persons with Dual Diagnosis had closed early on. Clover Bottom had closed, and I think it was 2010, and was planned to close. And the discussion left was whether or not Green Valley Developmental Center, the last large congregate facility in the state, would close. And we negotiated an agreement with the state on an exit plan. And Judge Sharp, in his approval of that exit plan in 2015, and that site is 2015 Westlaw 404077, he approves the exit plan. He denies intervention by a separate parents group at Green Valley, but he made a very important observation, which goes to our discussion of Olmsted in this panel. And he said that, he quoted Olmsted and said that the unjustified isolation of persons with disabilities, couldn't be tolerated, and that was why he was approving the settlement agreement, because the agreement would end that unjustified isolation. And I think part of that goes to show that jointly, protection and advocacy systems and self-advocates can address this civil rights issue by making state policymakers or decision makers realize that, these are persons. When you say persons with disabilities, the first word you say is persons. And you or I would not expect to be isolated, and neither should persons with disabilities expect to be isolated, nor is it necessary to isolate them in order that they receive services. The services they receive in the community are better. People make more progress. I remember vividly, I do not remember the young man's name, but a person who was at Green Valley had lived there all of his life. He moved out into a state facility. All of his life at Green Valley, he had had very, very serious behaviors, some of them self-harming. He got out of Green Valley and went into a community home. It was an ICF, but it was a 4-bed ICF, and it was basically like a supported living home. And within a few weeks, the behaviors were gone. And the only thing that had happened to him in that period of time was he moved out of an institution and into a community home. And his behaviors were gone. His demeanor, if you looked at his face and discussed it with him, his demeanor was entirely different. He felt, in essence, liberated and fulfilled. And I think that's what we are talking about in this joint effort by protection and advocacy systems and self-advocates themselves. And I don't know what my time is, but I'm close to 15 minutes. So I'll say two more things. One is, in the first session, there was a discussion about supported decision-making or decision-making supports. Tennessee has a website, www.tndecisionmaking.org. It is a joint effort with Disability Rights Tennessee, the ARC of Tennessee, and Tennessee's Developmental Disabilities Council. And the second thing I would say is, Kurt Decker is very modest. Everybody in this program owes him a great debt of gratitude, which we cannot repay, for his shepherding and nursing and protecting of the protection and advocacy systems. We really could not do it without him, and we would not be where we are talking about what we're talking about without his efforts. And we appreciate it. Thank you, Kurt, and I'll shut up.
Thanks, Jack. So again, the theme continues. Next speaker is going to be Tia Nalis. Tia has been a voice for self-advocates and helping people find their voices for a long time. Tia is the self-advocacy coordinator for TASH. She has been the self-advocacy specialist at the Rehab Research and Training Center within the Institute on Disability and Human Development at UIC, UIC, University of Illinois in Chicago. Some of the awards that Tina has won include the Burton Blatt Award and the Elizabeth Boggs Award. And Tia has also been very involved with legislative affairs and trying to change policies that inhibit people with disabilities from realizing the full potential of the ADA and Olmstead, and her work continues. Tia.
Thanks. First of all, thank you to Jack and Kurt for speaking first and sharing your information and how people with disabilities and protection advocacy can work together. For my experience is that first, people with disabilities need to be educated about what protection advocacy is all about and what they can do to help people if they need help on their rights. And so I think to start off, many people with disabilities need to learn about protection advocacy, and that's what we do in the self-advocacy movement, is try to talk about how we can work together as a team and making those things happen. So that people with disabilities, if there is any ADA things that happen that are being mistreated, people are mistreated under the Americans with Disabilities Act, then they could go into the P&A and talk to their P&A and see what the protection advocacy can do for them. Or the protection advocacy can also say, we might not be able to help you with this, but here is some more resources for you to be a part of that. As far as Olmsted, the same thing, people with disabilities that we've been hearing for before have advocated for people to live in the community, be a part of their community in all parts of their life, just like everybody else. So again, people need to be educated around Olmsted and the Americans with Disabilities Act so that they know what that is and they know how to tell when their rights have been violated. Some examples of talking about getting out of institutions and working together with protection advocacy. I know that in Illinois, when a lot of lawsuits or things have been filed under the protection advocacy court cases, sometimes people with disabilities will be a part of and give testimony on behalf of them. And trying to close the institutions. In other places, people with disabilities been active, being a part of closing institutions in many different ways. Some people first groups have filed lawsuits. Some people first groups have done legislation around closing institutions. And we need to both work together to make those things happen. So another example is Self-Advocates Becoming Empowered had worked quite a bit with talking about closing institutions for quite a long time. And so during our work, we have worked with many different people. We have worked with Judy and some self-advocates that were a part of Self-Advocates, probably worked with Jack and worked with Mel and many different other people that have happened. One of the things that we have also done is we worked with Kurt at NZRN around closing institutions. A lot of times people get a lot of heat for when you're talking about closure and closing institutions. For the protection advocacy, we try to help them find self-advocates who will speak up about that. And talk about how we could protect each other when the attack is happening. I remember one time Kurt was in a meeting, and it was a meeting where parents were in there and some other people were in there, and they were talking really bad about the protection advocacy, and nobody was saying anything. So I was like, wait a minute. You're just going to sit there and let him get attacked like that? That's not a way to let this happen, because we believe that people with disabilities should live in the community. So I spoke up and said, the protection advocacy is there to help people, and they're helping people with their rights, and they're helping people live in the community where they want to live and get the rights that they deserve. So we can help each other in many different ways like that. Some of the things that maybe the professionals can't say, people with disabilities can say when they're advocating in many different ways. So I think that if we all work together as self-advocates, like Cherie said, speak up, find other people with disabilities to speak up for people's rights. Go to some rallies and things that talk about having people have their rights, learning from people with disabilities about what they want, giving people a chance to let them tell you what they want, what their dreams are, and where they want to live and where they want to work and where they want to play. I think that you would be surprised that people with disabilities know what they want. With the right supports, they can do many different things that would be amazing to you that you would never think that people can do. As far as Olmsted, again, Olmsted has only had meetings in different states and not so many in other states. Some states don't follow Olmsted, and we need to advocate more for those kinds of things, for self-advocates to speak up. If Olmsted is not being happening in your state, you need to talk to somebody to make those meetings start happening again. I know personally, I had the privilege of meeting Lois and Lane in the Olmsted case, and also I was with ADAPT and TASH, some TASH members, and I'm sure some other self-advocates and self-advocacy groups, to sleep on the steps of the Supreme Court when the Olmsted decision was being made, and then got the honor to go inside the Supreme Court and watch it all happen and unfold. And to see that all of the hard work that those ladies have done to advocate, and all the other people who were attorneys on that case, and all the other self-advocates who pushed for and make that happen, had it pass. And we need to continue to speak up and support each other so that more of our friends could live, work, and play where they want to and have their dreams come true. So my challenge to all of you others out there who haven't worked with self-advocates yet, come talk to us. We can talk to you about many different things and work with you together. And for self-advocates, keep speaking up. If somebody doesn't listen to you, go to the next person. You're not alone. We're all here out there for you. And talk to your protection advocacy. They're there to help you. And so are many other organizations and lawyers that want to work with people with disabilities. And keep up the good work. Thanks.
Thanks, Tia. Kurt, Jack, do you guys have anything you want to add on to that as we start to wrap up?
I would just, well, thank you, Tia. And as I said earlier, I really want to make sure that the promise of Olmsted and community integration is real. And so one of the things I think we have to do as a community is, you know, and we are starting to do that now. And I think we have an administration that's going to be more friendly to our issues. But we've been talking to the Department of Transportation about the need to make sure that there's accessible transportation for people who are in the community, or they'll become isolated. We're talking to people at HUD about making sure there's accessible housing in good neighborhoods. As you know, because of NIMBY, you know, so many community residents are sited in some pretty terrible neighborhoods because that's the only place a provider can find, you know, a home. And so this is, Olmsted is really forcing us into looking at the full range of things that a person with a disability needs to have in order to have a really good experience in the community, and what we've told them is going to be a better life really is.
I think with regard to that question, one of the things self-advocates and protection and advocacy systems have to be very, very aware of is the unstinting desire of state legislatures to cut budgets. And I would say that being out of an institution means less if the waiver services that you go into, or the home and community-based supported living facility that you go into, is not adequately funded. Now, in Tennessee, if you look at TennCare documents, you see the statement with regard to the CAC waivers and the home and community-based services waivers that 10% of the people have 20% of the costs. Well, the reason that is because those 10% languished in decrepit, you know, abusive facilities for decades. And now of the state has to pay for them. And oh, by the way, what they're paying for them is not half of what they were paying for them when they were in institutions. You know, I mean, quite frankly, what drives institutions out of business is when self-advocates, protection and advocacy systems, and the Department of Justice sue them, and they get decrees, and the costs of services increase because they actually have to do what they're supposed to do to provide, you know, treatment and rehabilitation consistent with reasoned professional judgment. And that done properly is expensive, and that drives them out of business. But that doesn't mean they get a pass on what they spend in the community. And we need to be vigilant about that.
Thanks, Jack. We do have a couple of questions. I'll just read off. We have a question here from Alan Bergman. It says, thank you all for a great afternoon recounting our history and current issues and challenges. Following up on all the comments made about people with disabilities living in the community where they want and with whom they want and working at real jobs, we face a major hurdle in the future given the current version of the Better Jobs, Better Cares Act. It will put billions of dollars into the community for decreased DSP wages, increase DSP wages, sorry, we don't need to decrease them anymore, increase DSP wages and to reduce the waiting list, but it has, quote, no strings attached regarding Title II of the ADA, Olmstead, or CMS settings rules. What can we do to prevent states and the provider lobby expand the number of 6 to 8 person group homes owned by providers in segregated day programs, citing the great research from multiple sources that say 3 or fewer is the best number?
Well, Alan certainly knows, and I've worked with him for decades. We have a lot of work to do. There is still, even though things I think are getting better, I do think it's the glass half empty or half full. And you know, while we're making progress, certainly the wages for direct care workers are abominable. I mean, it just makes me crazy when New York City will pass a minimum wage for fast food workers, but not extend that to disability care workers. And so you can make more money in McDonald's in New York City than you can taking care of a person in a group home. And so I think it's, again, I think it's the marriage of the self-advocates and the legal groups to make sure that we educate these people that, you know, 6 or 8 people is not useful. Remember that we used to think 12 was great compared to 5,000 at Willowwood. And what's happened is we've learned, we've grown. We know that 12 was too big, and now we know 6 and 8 is too big. And you know, 3 is better, and 1 is even better. People should have their own homes and be able to own their own homes. So we've got to be vigilant. I say this all the time. We can pass the ADA, we can pass IDA, but if we're not on the ground every day, you know, making sure that those potential promises are working for people on the ground, they're just pieces of paper and nice looking things. And so this is why we need this constant vigilance by PNAs, by self-advocates. And now I think we'll have an ally, as Jack said, from the Department of Justice again, finally. But it is just, you know, we just can't let down our guard for 1 second, assume that we've accomplished everything.
Yep, thanks, Kurt. We got another question, and it says, and what about capitalizing on the fact that during COVID, a lot of people haven't been in segregated settings every day? How do we engage state leaders advised by self-advocates about what people really want and not to send people back to segregation?
Well, I have some answers for that one. I think that self-advocates can still, hopefully, if they have technology and the can do a Zoom link to their legislators or to other, our Department of Human Services. We have talked to them on Zoom about what the things that are important to people with disabilities and what's happening in our state and what they have done that's been really good for the state to help people with disabilities be a part of their community and want to have their own apartments and their own jobs. And also about how that our direct support workers could need to make more money so that they can help people get the supports that they need. I think you can talk to legislators. I think you could talk to your senators. I think you could set up meetings with your Department of Human Services and ask them to get on a Zoom meeting with you and educate them about that. And if there's any legislation that is out there, I know in our state, in Illinois, we have been doing testifying online with our legislators about certain parts of legislation that includes people with disabilities being a part of their community, working, and their support workers getting more money so that they don't leave and go somewhere else. So I think there's a variety of different ways that people can hopefully, if other people help them get the technology that they need to help them be able to talk to some of those people and speak up for what they want. Because it is really important that we don't let things go by the wayside as we are still in the process of trying to help self-advocates find their voice with COVID, and also set up group meetings with your self-advocacy groups and talk about the things that are happening in your state so that you can educate your other self-advocate leaders in how to talk to these people, the Department of Human Services, how to talk to a legislator, do some training around that. Now is a time that sometimes people are right now not having work because of COVID. And so instead of people sitting around all day and not doing anything, help them come to a training around self-advocacy and speaking up and why it's important to talk to people about the things that you want and your services. So I think that those are some good ways that people could still stay involved. And also people are still very lonely if they're not able to in their area go out as much and there's still big cases of COVID happening. They can set up some Zoom meetings like I did so that people don't feel segregated again. And we have a Friday coffee break and we talk about things that are important to us on this coffee break. And it gives people a chance to not feel so lonely, and then also do some advocacy work still and see their friends so they don't feel lonely, because that's the last thing we want them to do, because they just got out of those places and we don't want anybody to feel like they're back again in segregation.
Thanks, Tia. Jack, were you wanting to add something to that?
Well, I think that it's important to put a face on the situation, and P&A systems need to be as involved with self-advocates as they can be to publicize their situations, their story, their needs, their successes, their failures, everything that's part of being human that everybody else does, so that this, I can't remember, one of the speakers one time today talked about how a state legislator reacted when a self-advocate had something to say at a meeting or sent a letter. Well, that's because that state legislator was not learned in the situation. And we need to put a face. Self-advocates and P&As need to be out there. It's much better to have a self-advocate talking about, I'm living the life that I want to live and this is what I need, as opposed to a P&A lawyer saying, I will sue you tomorrow if you don't do this today. The self-advocate's the better way to go and the easier way to go. And, I did want to add one thing. We get calls every day at DRT about situations of abuse and neglect. And Kurt talked about access. One very, very important factor in access now is that when a P&A goes to monitor a facility and they want to talk to a person who lives there, they have a right to unaccompanied access to that person. That means that staff member that's been shadowing you for the last 4 hours as you wandered around the grounds can't go in that room with you when you talk to that person. You may have to tell them how you got to go, but that's a very, very, so then you can get the real story from the person with the disability, as opposed to the story that they tell when the staff member is sitting there watching them. It's a very important power that PNAs have as part of the access authority, and people need to be aware of it, you know, and use it.
This is Kurt. You know, I have to be honest, the COVID was an incredible challenge for everyone, but for our work as well. And just as Jack said, we had to go to remote monitoring, which is not ideal. And I think some of the PNAs were able to get facilities to give iPads to the individual so that we could talk to them, but we knew they were hovering behind them. And there was just no really way to guarantee that unfettered access and that privacy would be there. So we are now slowly getting back into on-site monitoring, which is really the key. You got to, just as Geraldo Rivera, you got to look and see and smell what's going on in those places. That's how you find out that there's a problem. We also learned, I mean, I guess it's a good thing we uncovered initially in the COVID epidemic that there were all these rationing of care policies around the country that said some people with disabilities don't deserve to get the primary care or ventilators or whatever. And so we were able to, I think, around 15 different states where we challenged those. And so it was a bad thing, but we discovered it and we were able to deal with it. And I know, for example, in Georgia, Ruby Moore and her people found out that they had a state policy that group homes couldn't get PPE. And so we were able to, they were able to move in there and say, wait a second, this PPE has to be for group homes as well as nursing homes. And so, you know, we've learned a lot about this. We're very nervous about, we've been hearing stories of people called back to work with disabilities and then not being called back to work as people come back on. And so I think we're going to have a lot of work to make sure that the people who want to return to their jobs are being hired back and we don't increase this terrible unemployment rate with people with disabilities. So we learned a lot. We've got a lot more that we need to watch.
Another thing is that people with disabilities can go with Protection Advocacy to talk to some people, other people with disabilities, because a lot of times people are scared to talk to what they think of as authority figure, and they don't feel comfortable talking. So sometimes that peer-to-peer support is the best way to go, where people with disabilities can do the talking to other self-advocates that are there and talk about what they want and how they, you know, what choices do they get to make and or not get to make, and the things that are important to them. I always say that peer-to-peer support sometimes is really the best way. It's sort of like when your mom tells you to go change your shirt, you kind of say, oh yeah, and you don't pay attention to her. But when your best friend says your shirt's ugly, you run upstairs and change. So there is another partnership that can happen, and when you're working together with people.